Now, when we were working on the labor disputes, we ended up with a list of 41 things that a good labor dispute court should do. They probably weren't all coherent, but they kind of give us an idea of what people want. And this is kind of what we'd like to do this afternoon. But I thought it would be useful maybe if we could start with the externals that we have here. If they would be willing to share with us one example, if they have one, of a court or a procedure they were involved in that went really well. Because we could quickly end up bitching and moaning about, and there'll always be a court somewhere that screwed up or took too long or was too expensive or da-da-da-da. But it might be interesting to turn that around a little bit and say, look, is there in my, your financial area, Gerard, or in any of the areas, Axel, an example of a procedure you think of that went really well? If we take some of those examples, we might start from that as an idea of trying to figure out of what a court should do. Anybody have something that comes to mind?
Should I kick on?
Yeah, why don't you, please?
What immediately came to my mind is the enterprise chamber of the Amsterdam Court of Appeals, and especially in a specific procedure at that court, which is the inquiry proceedings.
Right.
And there are a few features of this court and this procedure which make it really attractive. And first of all,
so this is a special. Sorry, just to interrupt. This is inquiry procedure. So this is a special procedure.
Yeah, maybe just for the people who
I think it's like me. What's the inquiry procedure?
Let's say, what is the basic? This is a procedure which can be used when there is a deadlock in limited liability companies. It's also used when there are, for public companies, when there is a shareholder dispute, a dispute between the shareholders and the company's management. And it can also be used more investigative after a major, let's say, problem. The court can appoint investigators who investigate what happened at the company and come up with a report which then can be used to initiate shareholder litigation, to initiate a settlement, can be used to see what measures you can take. So it's a procedure which was developed in 1971, was not very active until 1994, because at that point in time you also could ask for injunctions. And at the same point in time, a new president of the court, who was a really activistic kind of judge, who wanted to really expand on what was possible. So let's say he developed this area of the law, and although he now left the court for 3 years, his legacy is still there. And
but he also still there.
But yeah, he is a substitute judge, but he is no longer the chairman. So let's say he sometimes sits on the panel of one of the 5 judges. So
this is it's a fact-finding kind of inquiry procedure.
It's not only it can be used for fact-finding, but it can also be used to really come up with a settlement. It's also
Kijk naar Groening vis-à-vis LaSalle, was he allowed yes or no?
Yeah, that's maybe not the right the right example, but
the most famous example.
Maybe one of the most famous. I'm not there arguing the case, but when it comes to, let's say, smaller private companies, it can be used to settle disputes, and it's very effective because what sometimes happens is that the court appoints a managing director or supervisory director who can then bring the persons, the people together.
And what makes it such a good procedure? I mean, what are the elements that you think of? Is it?
There are a few reasons for that. First of all, the expertise of the judges.
Right.
Because it's a panel of 3 professional judges and 2 lay people who are normally accountants or former business people. So it depends a little bit on the kind of dispute who is involved from that panel of lay persons, but there are business people involved. So they have technical, let's say, the know-how. That's, I would say, one very good reason why it's effective. The second reason is that it's completely flexible. It's an equity court. Although we do not have the difference between common law and equity in the Netherlands, this is, in the way it operates, it's court of equity. Its example is the Chancery Court in Delaware. That's where they're looking at. So, and the flexibility means 2 things. You can come up with injunctions. Right. The court can give injunctions, so they are both, and we do not have the difference which we have in ordinary proceedings on the merits and injunction procedures, and those are handled by 2 separate judges. Now this is combined, interlinked.
Okay, so it means it can actually, I mean, it has teeth.
It absolutely has teeth.
Yeah.
And so what you can do is, let's say, appoint other directors, suspend directors, transfer shares in a company, the voting rights in the shares in the company. So set aside every provision in the Articles of Association, even set aside mandatory Dutch company law.
Could even liquidate.
Yeah, in the end, but that's not the answer.
Such an equity court, how does it ride with clients from outside our jurisdiction? Do they have such an all-powerful court which can do anything it likes in the interest of stakeholders in a company? How do you explain that to foreigners, and how do they feel about it?
Let's say they don't know it because it's unique. I don't know. I have no other. There's no other example of this court with this powers over the world. So sometimes there are. You have to explain a lot in order to give them a good feeling, and say that, let's say, although individual decisions you can always question whether right or wrong, but generally speaking, this court is effective. Also because it stimulates the parties to settle the dispute.
Okay. Right. Yeah, clear.
Yeah, I have a deadline if I
Thanks, Rich.
I have to join a call. I have a lot of knowledge on payments and securities, and in that world, rule books, master agreements are used among scheme participants. And in the rules of any of those rules books in the payment security forex industry, there is mostly a provision how disputes should be settled. It are mostly, the scheme participants are mostly in multiple jurisdictions by definition. And that means that one of the mechanisms to resolve disputes is mostly by some sort of arbitrage. The words are not always exactly the same. For instance, in Europe, for the rule books for SIPA, we use the Scheme Management Committee, but there are different words. But the strong point is always you have people sitting around the table who are allowed to sit around the table based on the rules. Who is allowed to be part of this cour d'arbitrage? they have content, and there are mostly also one or two independent. So they are coming from the industry, they know the tricks of the trade, and know how you should interpret the legal rules or the technical rules. And that element of content knowledge is very important to resolve it. And they also, in my experience in these type of debates, have stick if needed, because you can be kicked out the scheme if you do not comply with the verdict of the court d'arbitrage in a dispute. A similar mechanism exists also in ICC. ICC is very important for the UCP 600, which is for trade finance, globally very important. So if you do not deal with open account, but you use letters of credit, then you do it according to the UCP 600 rules. And the arbitrage mechanism of ICC is available in cases people do not adhere to the rules of the game according to the other party.
But these are generally business to business things, or not?
That's correct.
Right.
That's correct.
So it's within a
That's correct.
homogeneous community that has different interests, but
You have seen a bunch of competitors that are homogeneous? No. It's the
No,
cooperative space.
But you have some room to control that group.
Yeah, it's the cooperative space of competitors.
Right. Okay.
Are you also referring to the agreements in the context of complex financial products? Is that?
The ISDA master agreement has similar rules.
Because interestingly, we formed Prime Finance,
Yeah.
and now we are negotiating with ISDA to put, let's say, the Prime Finance mediation and arbitration mechanisms into the master agreement.
Yeah.
But we
Yes,
don't
the master
what
agreement
makes
normally-
it successful then? How would you say that? So what is it?
Well, in the end is market participant A and B, who are a member of a scheme, have a dispute. It should be resolved. That means there could be very large claim behind or very practical rules, the interpretation of nitty-gritty of the rules, which may have an important impact for the future.
So speed?
Speed is an important
Is
point,
critical?
yeah, because you may have exposures and you cannot wait too long. So expertise, speed is also an
And these courts of arbitrage.
I did not think about it, otherwise I would prepare
No,
maybe some other words.
Yeah.
I think particularly what you mentioned, the expertise in, let's say, in long chain situations is very, very important. Because if, let's say, in one particular part in the chain, there's a legal judgment which is solely related to that part, that have major consequences both upstream and downstream.
Yeah.
And that is, let's say, taken care of by judges who are not familiar with the case, then you really will have problems.
Yeah.
You have seen the research department of the Ministry of Justice did a project 2-3 years ago about specialization in the courts.
Yeah.
And especially in this dispute, business-to-business disputes, all respondents said we need more specialization.
Oh.
And the problem, at least in the Netherlands, is because the judges have to rotate from the criminal bench to the civil bench, and so it's very difficult to build up the necessary knowledge at judges. And that's really an issue, because as lawyers, which we are normally much more specialized than the judges are, and sometimes you see that they make, let's say, mistakes which are for an insider really stupid, but they are no insiders. So they're fine judges. That's not the issue, but they have no feeling for the environment.
Yeah. Dan, do you have any reflections on a procedure or process?
No, I think this appearance after the writ of summons and the answer is in the Dutch legal system so many cases are solved in this first appearance of the party. From a mediator's view, he would prefer parties to go to solve the problem outside the court. When they're in the court, there's a, let's say, a first step after the first written exchange of the writ of summons, so the parties appear, and then the judge, when he's skillful, can, in many cases, arrange a settlement or propose mediation as it happens. That we see there's in the civil courts, there's not so much enthusiasm with the judges for referring people to mediation in the purely civil cases, business-to-business cases.
So we've just done a quick overview of some of the things that have come up, the expertise. So we're trying to think of what would a really good court of the 21st century do for business.
If I may add something.
Yeah, please go.
What I always like, some people don't like it about cantonal judges, but it's what they do is usually, when you have the first hearing, they say, well, party A, then your case is not so good. So think about if you want to pursue this case. And B, think about what maybe is not so good about your case. So please go to the hallway, ga de gang op, and think about what I've said to you. And I think 90% of cases are being settled then. I mean,
okay. And what does that require? Because one of the things that came up, that requires judges that have a high level of expertise.
Yeah.
absolutely.
Specialization.
Absolutely. I do want them to give a well-thought opinion, not just because they want to get rid of the case. I want them to say something about the contents about the merits of the case.
So would you translate your requirement that there must be room for informality?
Yeah, but specialized judges. Yeah.
Well, I think it's very much comparable with the management conference in the UK, pursuant to the Wolf reforms. The Wolf reforms in '98 introduced this management conference, and the idea was that both parties, together with their counsels, would be called by the judge before the actual litigation would start, and then, let's say, by very ingenious questioning by the judge to both parties in the presence, and to let's say, both lawyers in the presence of the parties, these judges can easily convince the parties in the same way you're mentioning to try and mediate outside of the court. I think it's a very well thought of and very well organized procedure, but it requires some kind of change in the law.
Right. And where okay, so that's can you give a practical example of a case?
Well,
not a generic procedure, but a case where you thought it went really...
A case which eventually, let's say, well, what we did, remember that some of us know it, but at the end of the 90s, I introduced in AXO, let's say, mediation and other systems as preferred ways to resolve disputes, business-to-business disputes. And that was based on an analysis of many of the big cases we had. One of the big cases, some may still remember, that is the AXO Dupont case. You will remember that. So we then introduced this kind of all-in approach to disputes, which meant that we didn't look particularly for court cases, but in many instances, of course, you are, particularly if you are, let's say, on the demanding side, rather than the defending side, and the plaintiff side, then it's very difficult to convince the other party to come to mediation.
Right.
Now, our procedure, in many instances, particularly in the US, aimed at getting, let's say, starting the court case, do the pre-trial discoveries and all these things, and then inviting the judge to give a settlement order. And that helped very much, because in many of the cases, even if the other party was not willing to enter into mediation, let's say the settlement order given by the judge basically let's say, oblige the other party to sit with the mediator at the table. And in many of these cases, we came to very good conclusions. I think
Because I mean, a good judge makes himself obsolete in the
yeah, but
procedure
the judge should understand before doing that.
Yeah,
The judge should understand, let's say, the dynamics of the case in a business-to-business environment.
right.
And that's very
Coming into the expertise.
Yeah, it's interesting to hear these voices in the sense that it confirms a pattern that we saw from research into average disputes brought to civil justice courts. I was wondering whether these conclusions would apply to business disputes as well, but you seem to go into that direction. The conclusions of that research, in which we interviewed both the parties and the lawyers in 150 average civil justice cases, everybody in the courtroom expected from the judge that he took the lead in making the dispute less complicated, getting rid of the more extreme views, like you said, and actively managing. Of course, everybody wanted that the other party was managed by the judge, but the classical idea of a judge just being a referee who lets things go on between lawyers endlessly. You can still see these type of judges in common law courts, especially in the UK. That seems to be a disappearing view of what a judge should do. And this preference for informality, which means we still try to understand what it means, but the research seems to suggest that it means a more direct interaction with everybody in the room, less people speaking for a long time and the others listening, but more interaction, and that type of procedures is appreciated very much. But whether it works in real big business disputes where you have 500,000 pages of documents, I'm still not sure. So that's probably something we could explore as well. If you look at the real document-heavy proceedings, what type of and real evidence-heavy proceedings, what type of
I have an experience.
Yeah.
Based on the general approach which we took at AXO, was that in huge M&A transactions, I remember the sale of the man-made fiber division, 19,000 people in 35 countries with industrial operations. At the time you do the transaction, I'd say you put in the mediation clause, because what you don't want to have is that in each of these 35 jurisdictions, you have problems which have to be dealt with in each and every of these courts, and particularly if there are cross-border elements. So this is one of the examples in which I said, well, I don't want to have any, let's say,
because you don't want a court in that type of case.
yeah, you don't want the court, but then I'd say the other party should of course agree. And if you put it in the agreement, then basically, let's say the start for the mediation is already there. But the fact that once such a mediation clause is there, and once you are successful in resolving a couple of these issues together, you put all the issues after a year, because you're bound to have a lot of, let's say, smaller and bigger problems. Such a huge transaction. You put them all in the basket, and then you say, well, okay, this is what we do, we solve the problems. I'd say the idea that...
But our question of today is how a court would cope with such a case. You're talking about mediation.
Yes, yeah. I'm talking about mediation, but what a court could do in such a case is if the other party at a given point is unwilling, let's say, to go into mediation, the court would say, well, you have this mediation clause. What did you do in effect to get it to
Okay, but still you have cases where mediation doesn't work and then a court has to deal with such a big dispute. And the mediation clauses and the same true of arbitration clauses, they are still the exception. So if such a big case goes to court, what does that, how do you manage the documents?
It will probably end up being in courts, no?
In my view, and the courts and the approach should be very flexible. So I'm really in favor if you have a huge dispute and parties are not able to solve it themselves, that really at the start of the whole procedure you start with a process hearing in front of the judge where you can discuss how you want to proceed, how to go. Then sometimes there are preliminary issues which you have to deal with. For instance, jurisdiction, it could be discovery issues,
So early case management.
Early case management, extremely important because it can solve a lot of time and effort.
And what type of decisions do you then take in terms of handling this massive amount of information?
Yes, if it depends, of course, of the kind of case. Sometimes you can. There are in the Dutch law you have an obligation to come up with all your defences simultaneously at your statement of defence.
Right.
And the court is free to pick one or of all those disputes and then give a decision, which means that sometimes 80 or 90% of everything which is written by the parties, and the parties spend a lot of time and effort to present that to the judge, are completely obsolete for the court's decision. So a sensible thing what could happen is that if you see, okay, we have several areas, one of areas is simply a legal decision the court has to give, which is not dependent on the facts. Let's give a decision on that legal issue first before we go into discovery types of issues, because that's time consuming and very costly. And so, in my view, such an approach would be very helpful in order to speed up the process and limit the costs. And also because people are then coming together in front of the judge, you always see that will introduce more dynamics, which might make it possible to settle disputes. Or to appoint someone else. Let's say that's what you see in the enterprise court. You do not have a mediator, but the court simply appoints an independent director of the company, which can take all kinds of decisions, and who in fact operates like a mediator, but with one main difference. The mediator is completely neutral and has no power. This director has some power. And that's something for the mediation. The people who are in favor of mediation should also, let's say, look into whether sometimes it's more, it would be in some cases more effective if you would have a mediator who also has some power over the parties.
Yeah, or mediator, investigator combination. We see that a lot hearing as well.
Yeah.
In small disputes, but in these big disputes it works not.
Yeah, this small note in addition to that, and that is of course that the traditional role of mediator in the European context is that of an, let's say, facilitative mediation.
Yeah.
And we have a lot of advantages, we have a lot of benefits from the approach in the US, where mediators are more evaluative if you want them to be. So then that would tie into your comment, Ruud, that at some point the mediator actually can take a legal position, which you said also, and that helps the parties to proceed with the facts.
But for instance, instead of a huge discovery, appoint an investigator who is much more focused into what's really important, because when you do it the US type of discovery, 99.9% of all documents produced are completely irrelevant.
Right.
But still, there are voices to have more American type discovery in Europe, aren't there? Or is that?
We already have some more ADA, 43A, the exhibition.
Yeah.
We're already tending. It's not US style like, but it's more going that direction.
It's more UK like.
Yeah,
In UK there's a more, let's say, realistic approach to discovery than in the US.
Yes, I guess that's true. Because one of the, let's say, the traditional Dutch practice was that if you have bad documents, you just put them under the carpet and your opponent would never find out about it. And that's the way we operated. Even lawyers, when Maurits and I, we started at the same office 28 years ago, it was, let's say, completely normal. There was it was not considered unethical if you had documents which your opponents could rely upon hiding.
You don't have a law firm with a cut.
That's completely changed.
So now, if your client has the document, what do? You show it.
Yes.
Okay.
Yeah. But if you take the obligation, which there is now in the Code of Civil Procedure since 2001,
You're heading towards a quite almost impossible job description for a judge, no? I mean, so he's got to be highly specialized. The court has to have highly specialized, room for informality, be able to press for mediation, but at the same time take decisions. The earliest case management, be able to decide what's legal, what's not, what will I decide on first, what will I decide on next.
I think the management session
Right.
can also serve to do reality testing.
Okay.
As I said, let's say
So-
both for the parties, of course. If
Well, that's your point, saying,
It
you
would
know,
be good for everybody if early on during litigation,
right,
parties come to a settlement because maybe the judge points them into that direction. That's, I
Right.
think it's a win-win for the
Sure.
companies and for the courts.
so, yeah.
So they can still, how do you say that? Anyway, it would, at the moment we see of course a lot of court cases and we see cases going on for years and years and years. I would like an early case assessment, a case management session and maybe a judge pointing you in a certain direction. If the judge hasn't gone through the file, so it should be a qualified judge taking maybe more time at the beginning of the case than after years when he writes a verdict, he or she writes a verdict. Yes, I think you would like more interaction at the beginning. Yeah.
But again, I'd say that
That's
look
everybody.
at the case management rules in the rule reforms, because that's actually very well done.
Yeah.
Are there any figures on experience in the UK with the,
Oh, a lot.
with the success of it?
There's some research which shows that there's actually the earlier intervention and protocolization of the early part led to a cost increase in the early stages of litigation. Because if you have an earlier intervention, then the lawyers need to be prepared early on and need to collect more information and to cover all options and possibilities. So the optimism about cost reduction has not materialized in the UK.
But is it not that cases get settled earlier on because of this case management?
I've seen research about that, whether it's but it's a realistic expectation that it's easier to settle
Yeah.
cases early on than
But there's a lot of information already, let's say from the beginning at CEDA. If you go to CEDA, they will provide you with a lot of factual information on the effect of the early case.
Yeah, okay. That would be good.
Can I also ask a question from this perspective, guys? So, I'm the judge and I'm looking at you guys and you're all complaining about me and what would this judge ask you as corporates to do to make procedure, to make his court a court of the 21st century? So what are the kind of things he might be asking?
Well, only come to him if you really thought every other possibility over. Maybe you should have tried to mediate, maybe, well, yeah, at least for a settle if possible. So only come there as a last resort.
Right. Yeah.
I think the first question he should pose is, are you really interested in the legal solution, or are you interested in the business solution?
Okay, what does the judge want? What does the judge want?
Well, the judge should ask the question.
Well, that's what the judge should, but what does he want?
Basically,
Is a judge only for a legal? Would the judge say it's not legal, I'm not interested?
He has two roles. The first role is a facilitator,
Right.
to help people to settle the disputes.
Right.
And if people cannot be persuaded to settle the disputes, then he has to decide. So one of the issues you can ask yourself, if the same judge should fulfill both roles in the same case.
Okay.
And sometimes you could ask if the judge as facilitator in that role, he can be a little bit, let's say, more open, gives his views, but at the same time that makes him a little bit less independent when he thereafter has to take a decision. So I sometimes have the feeling that some judges feel uncomfortable to come up with their decision. So at least I have discussed this with judges, for instance, like Nienke Melissen, who's now chairs the Amsterdam say business to business disputes, and I suggested her in complicated cases do this pre-trial hearing, let's say yourself, but don't sit on the case. Just
So does that translate into a judge asking, just be very blunt, you guys, you should know whether you want me as a facilitator or as a decider, and you should make that more clear to me. Yeah. Here.
The dispute in the world I'm living in is not only for those who have the dispute, it also has an impact for anyone who's participating in the scheme.
Yeah.
It could be thousands of
Okay.
institutions. So apart from the bilateral fight or one against all or some against some, it's very important the speed, but also that the outcome of the process as soon as possible has an impact on the whole industry.
Okay. Yeah. Yeah.
Because it has to do with the interpretation of the rules of the rule books and the master agreements.
Yeah.
So it is a third party type of effect
Yes,
of
that's what
the
this is.
case in itself.
it calls for high expertise.
Indeed.
What we hear a lot from judges is that they hate long, lengthy documents, and that they see the size of documents increasing every year with 10%. Maybe I exaggerate on that. Is that something that judges would want, more concise documents?
I would say that there are two reasons why documents are more lengthy than they used to be. The first reason is that there is much more emphasis on facts, on fact-finding. So lawyers do a lot of more fact-finding also because of, let's say there is more discovery. Even in the Netherlands, although we do not have a full discovery system, we have very limited exhibition duty. But that's one of the reasons. The other reason is that people have to come up with all their arguments at the same time. They simply do not know what argument will be brought by the court, so they have to come up with that. So that's, I believe, those two elements are the main reason why documents are becoming more lengthy than they used to be.
So more facts and less ability to know
You have to,
which area of law.
you can. Let's say if you have a dispute, let's say, for instance, in a case where a claim was assigned and there was a dispute whether the assignment was valid or not, and you could argue that it should be decided in the Dutch law or you should be decided in the UK. So what are you supposed to do? Come up with a whole legal theory why it's not valid under Dutch law, and the whole theory why it's not valid under UK law, and also as a private intellectual law argument why it should be Dutch law or UK law, Dutch law is most favorable for you. If you would have the possibility for a court to take that decision first, then you could save a lot of time. That's my argument.
Yeah.
But that is already possible. I mean, if you go to the district court, you first have the jurisdiction incident, and litigants.
Yeah, okay.
Exhibition.
You also have the opportunity to come up with all kinds of incidents, but sometimes those incidents are also not very helpful because they are distracting the whole process. That's why you need early court assessment to decide how you.
And how can you anchor that in the procedure then? I mean, in terms of.
One thing I've seen German judges doing is that they don't have one case management conference, but they have a kind of ongoing conversation. So they say, okay, at the first hearing we will talk about this and this and this, and then at the end of the first hearing, the next hearing is called, and they say, okay, in order to prepare for the next hearing, you will do that, and we will talk about that. And so there is a kind of continuing story, and you grow together ever closer to a final outcome. And I've never seen that in Dutch courts or in common law courts. But it's a very common thing to do in German courts, but I don't know whether you have any experience.
In the US, you have more or less the same, because then there are conference calls with the judge, and there are issues which are on the table, and the judge encourages people to settle the disputes. And what's also very effective is in the US system that you write already the court order. And you present that to the judge as a party. And then the other party can exactly say, okay, but I don't agree with this, and I don't agree with this, and then sometimes they try to settle it, and
Okay.
they come up with a court order.
I've seen that in the UK as well.
It's very common, but here in the Netherlands, you only see it in pre-judgment attachment, and you see it.
Okay, then the parties write the order, or draft order, so that they're more focused on what a court can actually decide and can talk about the actual decision. Yeah.
And conference calls with the lawyers, very common in the US. And sometimes I've dealt with a court case in the bankruptcy court in New York. Every week there was a conference call, half an hour, about the progress of the case.
But it's very time consuming. What you say about the German system, you have this case management
It's
conference
time
a lot.
consuming for a judge, but my impression is that the costs of a judge in a business case are only 1% of total costs. So if that goes to 2%, then everybody's happy.
Yeah.
The only thing may be that the court fees are not accustomed to, not adjusted to the needs in business.
But that's, as I say, if you are talking about complicated business-to-business disputes, then I see no reason whatsoever that the court fees should pay for all the costs of the judge.
Yeah.
No, and I'm absolutely convinced that the parties do not oppose that. They're happy to pay for it.
Yeah.
If in the end it gets you a better, quicker result.
Bigger, quicker,
Quality.
more service. Also, one of the issues is, can we litigate in English in the Dutch court? It would be a huge step forward if that would be possible. It is already possible in one part of the kingdom, St. Martin's.
Yeah, these practical things are also important. Being able to conduct a conference call in that way that requires some skills from the judge, but it can be a very helpful way to manage a case, especially if you have a big business disputes where people live in different parts of the world.
And also in a court hearing, in the bankruptcy court, I have been present by phone here in The Hague, and was answering questions of the judge.
Yeah.
And there's no, that works perfectly. Completely outsourced.
Video conferencing.
And this has generally, I mean, is this happening? Is this an exception, or is it more, you say that?
It's not happening in the Netherlands, but it is happening elsewhere.
Elsewhere.
In the, of course, because the United States are such a big country, there's more need for, let's say, this techniques.
Right.
But they are available.
Oh, okay. No.
Yeah.
And what about the fact that a lot of disputes are increasingly, or I don't know, are they increasingly international? I mean, level playing field questions, procedure needs to be able to take into account. We're talking about these other stakeholders that might sometimes, need a voice. How does that relate, translate into? Is that an issue?
Sometimes, yeah. For instance, if a form of a Dutch court applies foreign law, you sometimes ask yourself whether that is the correct interpretation of the court itself. But I mean, that could be solved pretty easily by appointing an expert from that jurisdiction. That would be something better.
Right, okay.
Good judges, courts just hire a judge for one case from New York or from the Netherlands in Norway. Could there be some?
I haven't seen that you appoint a judge from another jurisdiction. You can. There are several ways to deal with, for instance, foreign law issues. The parties can provide expert evidence on what the content is. You have the here it's instituted in The Hague. Experts. The court can appoint an expert. So there are several ways of dealing with that.
I have a question on that, because you have that experience that the Dutch court at The Hague, let's say, basically applies Nigerian tort law based on English, let's say, case law.
Correct. And both parties provided opinions. In the end, of course, the Dutch judge, I think, decided more or less what the Dutch judge found common sense. I don't know. Looking at both opinions, and maybe we would have liked the judge to appoint an expert himself instead of interpreting those two opinions as he did now. But that's maybe too much into this case. But you are right. We had that experience, yeah. And yeah, we had two. I think even more. Both parties provided a lot of opinions. And I don't think I say something new if those opinions didn't match. So that's why I think in the end it was very hard for the Dutch judge to decide on those opinions. So that's why I think, that's maybe my personal opinion, in the end the Dutch judge does look at it from a Dutch perspective. Of course. Even though he has those opinions, he has to make something out of it.
Yeah, but I believe if those opinions are well argued, then it is possible for a judge to do that. I've seen an experience very recently with the Chancery Court in Delaware applying Dutch law. And you have 10 pages in the judgment about aspects of Dutch law based on the opinions provided and the translation of all the source documents. The important Supreme Court cases, the Osser, and then he came with a very concise and correct analysis of Dutch law.
To come back on the other stakeholders I'm involved in a company, being the chair of a company in New York, we have a serious patent case. And what happened in the process, it's basically this American company vis-a-vis an Australian company who claims to have the rights of the method, and patent law is complex. But in this process, which is still not on the content of the dispute, but on process law, what was done in the end, that other stakeholders joined already in the debate before we talk on the real content. So some of the very large companies like Microsoft, etc., had an interest to join already the debate in the start of the process.
And is that good for a procedure? Does it work, or does it complicate things?
From our perspective, yes. But it made also the life of probably the court easier, because the first round of the court was 3 judges, and in the end it was en banc, where all the full court had to form an opinion, and they were, let's say, I think, pleased with the fact that others who have knowledge about the nitty-gritty of the dispute formed also an opinion. It led to substantial more paperwork. That was the other side of the story.
Yeah. We've talked about paperwork and paperwork coming from not 2 parties but 5 or 7 parties makes it more complicated. Is there any best practice in how to handle paperwork right now, or is the system where each party determines how many meters of file we should or would like to submit is still the best practice? And you see a whole market of e-discovery systems, there's document management systems at law firms, etc., but they seem not to be connected to courts. Is that the future, that there will be interconnections, or?
It could well be that courts are taking over, let's say, the practice by mediators who say, well, I want to have, as a mediator, let's say, the main body of, let's say, of your case in not more than 20 pages.
Courts all over the world are doing that, setting guidelines for the document should not be longer than that, or you have not more than that many hours to argue your case, etc., etc. Is that the way to handle complexity?
It's not happening at the moment.
The district court in Arnhem has a rule that there is a maximum of 12 pages or so for each brief you file. Yeah.
Is that a pilot or?
Yeah, it's kind of pilot, but it's in the formal rules. And let's say I don't believe that's the solution, because disputes can differ. There are disputes where you need no more than 3 pages to present your arguments, and sometimes you need 200. It depends. And also when it comes to hearings, there is also a limitation in time you can discuss. So there is let's say a default situation if you want to have to have more time to present your argument, you can ask for it and the court will decide.
Yeah.
Yeah.
And I believe that functions pretty well.
Yeah.
I have the feeling that we are concentrating a little bit on Dutch courts and practice there, but we had some experiences from other countries. If you dig into your experiences in other jurisdictions, is there good stuff that comes from the Spanish courts or from Singapore courts, which are supposed to be leading in the world, or longer
Cases I
courts?
saw in the US are sometimes very unpredictable because of the judge system. And well, that's why for this patent case we are so concerned, because it was basically forum shopping with the level of knowledge of the court in itself was limited.
Yeah.
And if it ends up having a set of people who were selected to say yes or no, then it becomes even more complex.
Yeah.
I think there's one example in the IP courts in the US. Because, let's say, you have the jury system, and eventually the jury has to judge the facts. And what has been done in the IP cases, I'm not sure whether that was used in your case, is that development has developed in let's say, the IP cases, that the courts do what they call the Markman hearing. You may be familiar with that. Markman hearing is a hearing in which the court looks at certain facts and then comes to certain conclusions with respect to the let's say, the scope of the case. It basically precedes a kind of let's say, factual assessment in the end by the juries in trial.
So that's written
Markman.
Then?
Yeah,
like this?
Markman, the last E is in hearing.
Markman.
Hearing. Yeah. So that's in IP cases. Yeah.
That's because one of my experience is sometimes you have summary judgment in the US. So that's where you get a decision, let's say, based on the factual assumptions before trial. And a lot of, let's say, issues are taken out there.
Yeah, the research says that there's now only 2% or less if the cases go to trial, and about 30% of cases in the US are ended after a summary judgment.
Yeah.
That's particularly to respect to class actions.
Yeah.
But to create a contract in the US is also a simple labor contract with the CEO is 20 pages or more. It's also crazy because a lot of potential cases in a conflict in the future are already.
My own experience in summary judgment is that it comes quite late in the process. So it's done after discovery sometimes, which makes it a lot of the money is already spent.
Yeah.
So in my view, it would be very helpful if you could decide, let's say, certain issues as soon as possible.
Maybe as a final part of this very interesting meeting, when we looked at the procedure for labor law, then we also took the perspective of the Minister of Social Affairs. Okay, what kind of labor procedure would help the labor market to perform in an optimal way? Could I invite you to think about it in the same way about business disputes? What does our economy need in terms of this business dispute resolution? What would help to get our economic growth back to the positive percentages? Could business procedures help for that?
Patent law probably. There are more and more practices to submit way of working becoming a patent.
So, that's business
pushing
method patents.
Yeah. Vision. indeed. And some pushing back will be in the interest of ministers of economic affairs in particular.
Yeah, but that requires legislation.
I agree.
Well, let's keep it open, and could also be the courts who say, what a very effective court like the Amsterdam court, the business court, what could it do more to let the economy flourish?
It's a bit of an open door, but it's again the early case assessment
And
early settlement.
Yeah. So it's all a matter of being fast.
Yeah.
Yeah.
Yeah,
One of the things that comes to my mind is that when I read the financial newspapers, I read a lot about many claims and debts being unclear what their value is. And so on the balance sheets of banks, there's a lot of shit, and because everybody knows there's a lot of shit out there, and nobody can see what the actual value of a bank or a company is. Nobody wants to buy it anymore. And of course, part of that is also a matter of fast bankruptcy procedures, fast procedures where the value of claims that are disputed can be established. Is there something business courts can do in that respect?
Yeah, it depends a lot about the type of dispute there is. When you now mentioning the value of claims, but you could also, and there's a specific problem when the value of a company is less than its debt, because it then should be reorganized.
Yeah.
And one of the issues is that why you see Chapter 11 in the United States is so effective, because it is a procedure which has an emphasis of bringing all those creditors with all kind of different interests together and come to a certain solution. That's a good thing. The bad thing is that it is extremely costly, and also there's a lot of red tape, all kind of documents you have to. So if you want, for a problem like this, come up with a procedure, you have to make a court competent, who can impose on parties a plan of reorganization, because that's if you could do that, that would save a lot of money. Let's say Reinhard Friesendorp and I did that. We actually, for the Netherlands, wrote down a new title to the bankruptcy code, which the minister. No, it's not a pre-pack. It's the plan of reorganization, the accord. And last week the Minister of Justice announced that this will be introduced now.
There was some pressure in the media as well to do it.
That's that kind of thing. But this is for a specific problem. Right?
What about, and nobody in Holland knows the value of insurance companies, because there are still a lot of claims pending against these companies because of cheating the customers of financial services. Is that a thing that would help the economy if this kind of claims would be more clear, and perhaps foreshadow specific types of claims regarding to the environment would also, if they would be settled or the value would be clear, it would be more clear what Shell was worth. It's a lot already, but
it's a bit hard to answer, because the question itself, what Shell is worth, is normally not what we are litigating about. Maybe it's more relevant for insurance companies.
The financial services industry is really suffering about all this disclaims. These are not business to business disputes, business to consumer disputes, in fact mass disputes. And the problem is, how can you solve those problems? And what we have seen in the Netherlands, no, not in the Netherlands, generally speaking, there are a lot of situations in which the compensation offered to consumers who bought this kind of products or having other kind of claims was not enough. And therefore it took a very, very, very long time to solve the issue. You have seen it in asbestos cases. James Hardy is a perfect example. An Australian company who came up with the first compensation plan. You have seen it in the Booker products. There is in Hong Kong, you had exactly the same kind of investment, for a retail investment product, which was sold to consumers. They suffered losses. The initial compensation was too low, and therefore it was forced to do it all over again. And as long as you haven't solved this problem, the company is in real distress. So the issue is, how can we come up with a solution to solve the dispute, which is both at an early stage, which is both beneficial to the company and the consumers. And in fact, what you see with the insurance companies in the Netherlands, they're suffering it and they have no solution.
Yeah. That's a legislation question.
No, not a legislation question. It's simply you have to see how to sit together. Sometimes it works. For instance, take the DSB bank bankruptcy. That's solved with one single court case before to declare the settlement binding before the Amsterdam Court of Appeals. So it is possible.
But if there's a willingness on the side, of course.
Absolutely.
Talking about the pre-pack solution, that some courts think that it should be possible without, let's say, new legislation, and others think that new legislation is needed. So there is this kind of controversy within the courts.
But that's true.
In bankruptcy, we can choose a form, so it's not a regulation.
I think, like in the Zuckerpolis claim affair, is it not the problem that those foundations never started any procedure? I mean, because it is possible to start a collective action.
Yeah, but
they didn't.
Yeah, but even a collective action in itself doesn't solve the problem. The problem is you have to come up with another idea. I'll give you just another example, which is very discussed last Friday. I'm representing Intech. Intech has a dispute with its shareholders, and together with the VEB, we already had an outset of a settlement, because Intech cannot pay any compensation. It has not the funds to do so. So the basic idea is that we issue warrants. So if the company will has compensation to its shareholders, now we have to find.
There's a lot of creative suggestions about settlements that should go to the judge, and
but it's not. I believe, from the perspective of the judge, it's impossible to impose such a settlement.
Okay.
So what do you suggest then in those cases?
Let's say the representatives of both parties should be creative and come up with a solution.
Then may I come back to you and ask you, I know that there has been quite a movement to go for mediation in business dispute. Some mediators profiled themselves during the last year with business mediation opportunities. How do they fit in with business courts? What is their link, and how can they offer services which are of added value to courts?
Well, I think that it has to start yet, this link between this mediators and the courts and say the civil chambers.
Okay.
It's kind of, it's my experience, small experience, as a replacement judge and contacts with presidents in Rotterdam and here in The Hague on commercial civil cases, that there's a kind of gap between those chambers and people active in mediation. I think there's needed more exchange of experiences and more exchange of knowledge of each other. Okay. So it's a process to start yet, I think.
Would it be worthwhile, let's say, requiring judges to follow a mediation course?
They did. Some did. Some
yeah,
did.
But then you have to go through a real, let's say, good mediation.
But after Martin Pell left, the number of courses at SSR for judges in mediation went down. The number. I always shouted Martin away, mediation away. You have to be careful that with the motor of mediation within the court system, there's no subsidiary for that at the moment. There's not from the Council of the Judiciary. There's not a strong motor for mediation. The old judges doing that.
But I think it's essential, let's say, for a judge to really understand the process.
Yeah.
Well, I think there is one opportunity there to let judges learn more about different dispute resolution techniques, especially mediation, but there's also clear messages that judges should be specialized if they deal with business disputes. That's one of the very clear outcomes of this meeting. Which I'm trying to bring to an end because our experience is that Monday afternoon sessions, they're good if they start at 5:30 and really end at 6 o'clock. So I would suggest that if you want to give us one final thought from your perspective, what should be in a report about the future of courts for business perspectives, from the perspective of business dispute, that would be great to have one final thought of our 4 remaining visitors, and then we conclude. And you're, of course, still the beer will not go away, and you can stay with us for some more time.
Thinking aloud, what about what we would call a kort geding,
Yeah.
but where you have the possibility more to deliver proof, maybe even by witnesses. So not a short kort geding 1 hour, maybe a morning or a day. Or so like a trial you have
in between
yeah.
size procedures. We will look for a better word.
Yes, it's not correct, but exactly the kort geding.
I guess a similar analog would be in the U.S. criminal system. Before trial, there's a evidentiary hearing where you have to enter all or at least most of your evidence you have at that point. And there's just a slightly lower standard of evidence at that point. And then from there, if they establish it meets that criteria, then it goes to trial. So maybe a similar analog of that.
Good. I have a very interesting experience in that respect.
Do you have a final suggestion?
Yeah, and that is, I'll say, the experience which I have. We had summary proceedings brought against us, and we didn't think that, let's say, the question was really something to be solved in summary proceedings. So we suggested to the judge that he would use this as a kind of start of the voting procedure. And then he said, okay, I have now these materials. Why don't we set a date 6 months from now where you can give your pleadings. So that advanced, let's say, the whole procedure immensely without, let's say, taking into account the difficulty in having short summary proceedings.
Any final thoughts from you, Jan, about what business court should do?
Yeah, I think I would support Ruud's position that increasingly, let's say, problems include more than one, let's say, plaintiff. So you have mass situations, both in the field of, let's say, of environmental issues and in the field of, I'm thinking, let's say, of my experience in antitrust cases.
So courts could...
Well, it would be very helpful if courts would facilitate mass proceedings, because it would also be in the interest of the companies, but not on the terms which are valid in the US. So, not, let's say, difficulties with jury proceedings and things like that. So, if it was single damages, with a good establishment system for the, let's say, the level of the damage, then it would be very helpful for companies to have this type of procedure.
With fair, facilitate mass claims with fair, and that means at least single damage.
Well, yes, and a good system, let's say, for the establishment.
Don, any final recommendations for
already make, to zoom in on this second different roles of the judge, I would split it. So have people in courts who are facilitators for this pre-session, not highly experienced judges or experienced judges, doesn't matter, but make that a new work, that's a description of a job in a court.
So there's one judge,
not only
sides, and one facilitator.
First,
and they can be different people. You can afford that in business disputes.
30 judges, you can pay one from outside, train somebody to do just that work.
Good. Any final?
I would say my key taking would be the focus of the procedure would be on focus on solving disputes, and deciding these disputes is just one way of solving